We're on the record, Your Honor.
Okay, we're back on the record. In the matter of Horodesky, nothing what I had hoped. Well, that's not exactly true. We had a technical glitch and we were not able to do what I had hoped we were going to do, but nonetheless, we got it done. It's my understanding Ms. Robinson did receive the report from the court, and Mr. Carmen read the interview to his client, so we're in the same place that we would have been otherwise, and I apologize for all the delays. So, Mr. Carmen, you wanted to make a record about your concerns with the report. Now is a good time for you to do that.
Okay, and Your Honor, the concerns of this, number one, this is here before the court. The one remaining motion before this court is Amber's motion to reconsider. She cited 52B and EDCR 2.24. Nothing else is pending before the court at this time. At the last hearing, the court took testimony from the parties. We weren't allowed to cross-examine either of the parties after the court questioned them. The court issued orders related to weekly telephone contact that were not briefed, were not before the court, were not noticed. Court ordered a child interview. The child interview has been conducted. It was not recorded. The Supreme Court has indicated that a court should not be reviewing a child interview unless it's been recorded. This is concerning me that this case is going in a weird direction. And the reason it really concerns me is because of the Dr. Mullen report that led to Judge Forsberg's order. And again, we're here for you to decide whether Judge Forsberg acted appropriately in issuing her orders previously in this case. I really do question whether this court has authority to review that. But I understand we're proceeding. It's not the best of circumstances. The court indicated that didn't feel comfortable that it could remand the case back to Judge Forsberg. But I'm really concerned that you're reviewing new evidence that shouldn't be considered in determining a motion for reconsideration in the form of the child interview report that was done by FMC. It wasn't recorded. And the reason I'm having such a big concern about it is because of Dr. Mullen's report. Dr. Mullen did a thorough child interview report. That child interview report brought to light many difficulties. The child was made aware of the purpose of the interview before he went to Dr. Mullen, and told Dr. Mullen that the case had begun because Dad was molesting me, which again is being repeated in this report. Dr. Mullen indicated that he had a glorified view of his mother and a distorted view of his father. He viewed his mother in a distortedly positive way and his father in a distortedly negative way. She talked about how the reporting was inconsistent depending upon who dropped the child off for the interview. Specifically, Dr. Mullen said when Mom dropped the child off for the interview, he came in with negativity toward Dad. When Dad brought the child in for the interview, he spoke differently about Dad. And she chalked it up to a child who has a lot of issues. According to Dr. Ali, who she had spoken to, he had adjustment disorder, major depressive disorder, and ADHD issues, which she believed impaired his ability to really accurately recite truth versus distorted views of the parents. In Dr. Mullen's report, she repeated Lynn Conant's testimony to the court that Hayden doesn't tell the truth. When Lynn Conant was asked about the custody schedule, she indicated that the custody schedule was appropriate and that the child needed additional time to bond with Dad. In the end, Dr. Mullen's assessment was, this child is not a reliable interviewer. ADHD leads to him making impulsive statements. He's reactionary. He tends to minimize his own consequences. He glamorized his relationship with Mom while disparaging the relationship with Dad. She expressed concerns that when Hayden was interviewed contemporaneously with Mom, they used the same language. They repeated the same things. And it clearly was a sign of coaching. And she emphasized that this is an emotionally vulnerable child who is focused on pleasing those he sees as an authority figure. So in other words, by Mom bringing the child down to this interview, and the questions didn't get asked, I'll explain to the court what happened with that, but I believe we have gotten a very lopsided child interview report. And again, I'm really concerned that the court's giving any weight to this, because it should have no bearing as to whether Judge Forsberg acted appropriately in making a determination prior to Your Honor hearing this case. But in the end, Dr. Mullen said we have a child who tells parents what they think they want to hear. And it goes down to what I was trying to say at the last hearing. I understand Your Honor's order. You want this child to have unfettered telephone contact while he's at the other parent's house. I agreed with you. In a perfect world, that is absolutely what should happen. But Dr. Mullen specifically indicated that it's not helping this child in this case. It's not in his best interest, because it's creating more anxiety. It's creating triggers feelings of conflict for the child. And now we have a child interview report. And again, I don't see the new child interview report being anything different than the last child interview report. The only thing I see different between the FMC report and the Mullen report that Judge Forsberg relied upon is that the Mullen report went into depth. It interviewed the parents. It looked for coaching. It looked for the underlying problems that are causing this child to have such distorted views of each parent. It looked into the fact that, when one parent dropped the child off for an interview, they testified very differently. And throughout the entire interview, Dr. Mullen was able to observe, again, because it was multiple interviews over multiple days, that the child's reports are simply not consistent. In her report, he'd give a report one day of a dramatic story that happened at Dad's house. He'd come in 2 days later, and he'd change the facts. He'd change the details. So I'm really concerned about Your Honor relying upon this single report by FMC that hasn't been recorded, hasn't been vetted by an expert, and it's with mom having dropped the child off. Frankly, I'm almost surprised it wasn't worse. The fact that the child rated the parents within 2 degrees of each other on the 1 to 10 scale, it seems like it might be an improvement as to what the child said to Dr. Mullins, but it leads back to the same thing where, I'm extraordinarily concerned that the court is relying upon the statements of a child who has consistently rendered inconsistent comments, and they're all geared toward Dad, who, of course, the child thinks molested him when he was young, based upon comments from Mom. So and again, we're back here for another hearing. And, at the last hearing, we talked about the past with Mom filing papers with this court improperly. She has an attorney of record. She keeps filing things improper. Judge Forsberg, before the hearing back in, I think, June of 2019, dealt with this. Mom filed a bundle of exhibits a couple days before the hearing. Judge Forsberg struck them, informed Mom they were inappropriate, gave her a chance to withdraw them, and admonished her not to do it again. And now again, on the eve of a hearing, exhibits are filed by Mom. I'm asking this court to make a decision on the motion to reconsider, and just to be very cautious in going forward based upon the reports. There's a long history in this case, I'm hopeful that Your Honor, after the last hearing, has reviewed Dr. Mullen's report. But there's an awful lot of history, and when considering whether there should be a change of custody or we should move forward on any type of custody issue, there has to be a motion. There has to be notice. We have to determine whether Judge Forsberg's order is the last custodial order for the purposes of res judicata. And I'm asking the court to kind of lay out where we are in this case, to make rulings upon the motion to reconsider, and if a custody request or any change to the custodial arrangement is going to be made, that the court require the filing of a motion, allow Dad to have notice to respond, and apply Rivero. I understand the court, your comment that you have the ability to render any order in the best interest of a child. That is very tempered by Rivero. When a parent has primary physical custody, there has to be a substantial change in circumstances directly affecting the welfare of the child. It is not simply best interest. There is a burden placed upon the moving party. And I do believe Judge Forsberg got it right, and I'm really concerned where this case is going. So,
okay. Thank you, Mr. Carmen. I'll note also that you filed a motion to withdraw.
That's correct.
So where do we stand on that? So you're still counsel of record for today, because if Mr. Horodesky is not objecting to your withdrawal, at what point does your withdrawal become effective if it's by consent?
Well, it's not by consent. It's by circumstances, because Mr. Horodesky has no money. Unlike Mom, I mean, he doesn't have a spouse that's a medical professional supporting him. He's trying to borrow money from family. He's trying to address his financial situation. If it's not addressed by the date our motion is set, we are going to unfortunately have to withdraw. But this is not a withdrawal that Mr. Horodesky is asking for, or frankly that I'm asking for. It's a withdrawal caused by his financial circumstances right now.
Okay, thank you, Mr. Carmen. Ms. Robinson, well, I'll make one comment before I have Ms. Robinson respond. Ms. Robinson is not counsel of record. You said that Ms. Johnson has counsel of record, and that Ms. Johnson should not be filing things on her own. However, that is not true. The rules, the EDCR allows for the rules in general allow for attorneys to be retained unbundled in an unbundled capacity, and Ms. Robinson has repeatedly made it clear that when she makes appearances here, she is in an unbundled capacity. And so therefore, in between her appearances in court, Ms. Johnson is self-represented. However, I don't know if it was this case or another case where I've expressed my frustrations in the lines, the blurring of the lines when an attorney is unbundled and when they're not. And, at what point does counsel of record, such as yourself, contact the unbundled attorney or contact the client directly? I get that, and I'm really very excited about the new rules coming into effect, because I think that will help eliminate a lot of those problems.
And Your Honor, I think the current EDCR 5.209 addresses those problems, and if the attorney doesn't state with clarity the scope of the representation in their entry of appearance, they are not unbundled, and a notice of withdrawal is not valid for any purposes under the rule. I mean, I think that Your Honor's frustrations have already been dealt with under EDCR 5.209. The problem in this case is we don't have that clearly defined scope in the entry of appearance, and the notices of withdrawals have been inconsistent throughout the course of the case.
Okay, thank you, Mr. Carmen. Ms. Robinson, I'll let you respond.
On the subject of unbundled work, I have been unbundled. It's been Amber doing all of her written work, and I've been doing the appearances. And this case has been rather unique because almost every single hearing has required further work and further communication between myself and Michael Carmen, even though I was only hired for a specific hearing. For example, the December hearing, or January hearing, excuse me, then Your Honor wanted calendars and that kind of thing. So it's I stayed on to get that done, and then, I'm rehired for the May hearing, and now we're having a child interview, and we're continuing the her motion hearing that was set to be heard in May. So it's where is that line drawn? I was hired for the hearing, I'm hired for today's hearing, but I'm really not hired for the in-between. And so should I be filing all these withdrawals when the court is still wanting things from me? I don't know. I mean, I understand counsel's frustration, but I think he also needs to understand the uniqueness of this case, where it's not your average case where we get into the hearing, we get the order, and we're completely done.
And understand, Your Honor, my frustration isn't with Ms. Robinson. It's with exhibits being filed on the eve of a hearing where no attorney would have time to sit down with their client to discuss them. And it's been a consistent problem throughout the course of the case.
I understand, Mr. Carmen. So, Ms. Robinson, did you want to respond substantively to Mr. Carmen's other statements?
Yes, well, just overall to the child interview report, I was surprised to see in the very beginning of it, FMC had said it hadn't received my questions on behalf of my client. We submitted the 20 questions as the court directed. The court directed us to submit that directly to FMC, and we submitted it that Friday. So I have concerns that our questions weren't asked of Hayden. I mean, it looks like opposing counsel's questions weren't asked either.
Yeah, and I'll support Ms. Robinson on that. We had trouble trying to figure out how to get the questions to FMC and whose attention they should get to. It got to the point where I did a formal letter because my staff couldn't get a clear answer as to where they should have been emailed.
Yeah. Oh, that's unfortunate. Yeah, I don't know. I know in the past when I've been a practitioner and the judge has ordered that questions could be submitted. Yeah, I should
In hindsight, I think we should have.
Where do you submit them? Yeah, I get it.
I think in hindsight, we should have submitted them to Your Honor's clerk to make sure that we were covered. But it's unfortunate they had some questions and didn't ask them. And yeah, Mom's question should have been asked as well. I'm actually supportive of that.
Anyways, go ahead, Ms. Robinson. I'm sorry we interrupted you.
And then to go to Mr. Carmen's statements about whether or not this child interview should have been ordered in the first place, I mean, I think this kind of stems from all the December and the COVID incidents and our hearing in January and the calendars. And Your Honor's allowed, as you well know, to make sua sponte orders from the bench. And so I think you were just trying to gather more information. I don't think that the court necessarily needed a motion request that we have the child interviewed again. That being said, what's contained within the child interview, Hayden is saying, I do want to be joint with both parents. I'm tired of the push and the pull, and I'm tired of all the negativity. And he specifically mentions that on Dad's end. I'm tired of all the negativity on Dad's end and the constant talking about court. And I want 3 days with each parent, 3 days on, 3 days off. I think I read the report as he's just tired. He's tired of constantly being in litigation. He rated Chris, which I thought was interesting, his primary parent, he rated Chris lower than Amber. He rated his sister and his mom's household. She was the highest rated. She got a number 10. He rated his stepmom poorly. He rated his paternal aunt poorly. But he rated Amber higher, and then he even rated Amber's husband higher than Amber. I think we should give some, and I'm sorry, it's the end of the week, I'm just tired, but some credence to what, and that's probably not even the right word, but let Hayden speak. Like, he is 16 now. And then when we did the last child interview that took months and months and months to obtain, I think now that interview is, a year and a half old?
Yes.
And we're in different times now. Overall, our motion for reconsideration, I think I already addressed everything at the last hearing. There were so many problems with the judge's final ruling. It was almost as if she based her final ruling solely on the child interview, but she doesn't address the joint legal custody violations. She didn't address the substantial change in circumstance. Alone, just with the child's grades, at the time that we brought that motion, just with his grades, there had been a substantial change in circumstance, and that's what the whole Ellis case was on, was the child's grades. So how we never even got an evidentiary hearing just on that alone, plus everything else that we've alleged again in the motion for not we, sorry, but Amber, but we, because I am representing her today. She recaps everything very well in that motion for reconsideration as to how none of this was addressed by Judge Forsberg, and it does seem to lean entirely on the child interview, that Judge Forsberg, with all due respect, interpreted it a certain way. I didn't read the former child interview so stringently against Amber. I thought it favored Amber pretty well, and I think it favored all of the things that she's been alleging in the last couple of years. Like, for example, Chris calling her an antichrist, that was brought up in Dr. Mullen's interview as well as this interview, and in Dr. Mullen's interview that was supported with pictures that we had attached showing what Amber is, like, pops up in Chris's phone. She pops up as a wolf in Chris's phone. Part of what I think led to the child interview was the other side saying that the child was terrified. I think they used the word terrified to be in mother's care. That absolutely didn't come across in the prior child interview, and that's not coming across in the interview today. We're just asking for a fair shake, Your Honor. We realize that this has been long and litigious, but Amber, several years ago now, brought very good points to the court that the court needs to look into. The grays, the joint legal custody violations. Let's look into this, Your Honor. The lack of contact also was a big thing, and it still continued to be a big thing even after Judge Forrest, and still now, even after 2 judges have again said, you need to allow the calls, you need to allow the FaceTimes, and it just doesn't happen, Your Honor. We've had perpetual violation, not violation, but alienation on Dad's part over and over and over again, and it's having drastic effects on this child. But we are asking for the court to reconsider that prior ruling and the prior ruling in regards to attorney's fees too. There were no findings made as to how, we're assessing that much against Amber, and it did not take into consideration her financial situation. I know that Mr. Carmen mentioned that her husband is a doctor. I'll tell this court that she doesn't get money from her husband. I've not once been paid from her husband. I've been paid from her parents. It would have been easier for Amber. Her husband does make good income. If she could have hired me on full time, and she is not in a good position to be paying those attorney's fees either. And then on attorney's fees notes, I was going to make an oral motion if the court would allow that real quick.
What was the last thing that you just said, Ms. Robinson? I didn't hear that.
I wanted to make an oral motion just while attorney's fees was on my mind, because I saw the judge's minute order from 2 days ago. The court has denied my client's attorney's fees that were awarded in May. You directed me at the May hearing to file a memorandum of fees and costs. And I just wanted to make an oral motion to set aside the minute order. We had continued that hearing, that Friday hearing, and so I ended up being in the hair salon during our last hearing, and I apologize, Your Honor, but I normally, like when I'm given deadlines sitting here, I'll just type it into my calendar. So I didn't do that at the hair salon, totally missed doing the memorandum of attorney's fees and costs. So now the court has denied those for Amber, and I just also wanted to remind the court, the attorney's fees that I was just talking about that were assessed against Amber, that memorandum of attorney's fees came in like over 100 days late, I think maybe even 150 days late. And then here I am, I didn't do it, and it's been like a span of maybe 30 days late. And I just don't want to prejudice the client for my failure. And so I am asking the court to set aside that order.
Okay, Mr. Carmen, I'll let you.
Let's respond very briefly. Again, my primary argument, though, is that this court just doesn't have the power to reconsider the orders rendered by another sitting district court judge. I think there's a jurisdictional problem. I mean, this court cannot sit in the position of a reviewing court. That would be up to the Court of Appeals. In response to Ms. Robinson's comment, the fact that Dad, the primary caregiver, is rated lower in this case is exactly why Dad has more time with the child. This goes back to an evidentiary hearing with Judge Potter, I believe, who issued the initial order giving Christopher primary custody. It was after the testimony, it was after considering the experts, it was after considering everything. And the reason that Dad needed more time was to offset the negativity. And again, there's negativity both ways that are noted in the Mullins report and in this report. But the problem is the child is aligned with Mom. And the child needs additional time to bond with Dad. If without that time, it's unlikely the child would have any relationship with Father right now. That's been the history of this case. It's been the order of this court, and it should remain the order of the court. It shouldn't be a surprise to Your Honor that his number is lower. When a child is aligned with a parent and has an unhealthy alignment with a parent, they're going to rate the parent to which they don't have that alignment lower. There really are no problems.
Who said it's an unhealthy alignment with Mom?
That was, I believe, the Judge Potter order is after the evidentiary hearing. That's why Christopher, in part, received primary physical custody. I mean, it was way more involved with a lot of credibility issues, a lot of problems with the party's testimony. with mom's testimony. But in the end, the repeating history in this case has been that the child is aligned with mom and is aligned against dad. It was noted in the Mullins report. I mean, it's the same problem.
It was, and I find that interesting that you bring that up, because the last several times during hearings, you've said the opposite. You've said that the child is afraid of mom, that mom has basically, what's the word, not kicked her out of the family, but has basically stated that he's not a member of the family, and that he's been disenfranchised from mom's family, and that there's a large separation from. So, but now you're saying the opposite, and that's what Ms. Mullen, Dr. Mullen said, and that's also what
it's
FMC
not really the
interview said. So
the
I mean,
problem.
and I also seems like I also heard you say earlier that these reports were virtually identical, and then you said all of the reasons why they're different. So I'm really.
I don't think they are different. It's the same old, same old. The difference is that there hasn't been a pattern of interviews for which the interviewer can see the inconsistencies in Hayden's reporting. The distortions of the parents are still there. The things are still there. When I say that Hayden is terrified of his mother, he's terrified about speaking against her. He's terrified about words. He's not afraid of being in her care. When he's in her care, he tells her what she wants to hear, as we know from Dr. Mullen, and everything's fine. It's when he's interviewed, he is afraid of the repercussions of what he says. And again, I understand the court doesn't necessarily believe what was stated at the last hearing, but when his mother called and said he's no longer part of the family, he was terrified of repercussions when he went back to his mom. It's the repercussions of the litigation, of his comments, of him saying something positive about his dad. It's not the type of terror that Miss Robinson was describing.
Well, I'm not. I mean, gosh, you're so. It's amazing how different your perception of this is than mine. I don't see that at all. I'm looking at the child interview that was conducted on June 4th, a month ago, and it essentially confirmed my gut feeling, because I did not believe that the child was afraid of mom. I don't believe that mom ever said that the child is no longer part of the family, or whatever it is that you're claiming was said. I don't believe that happened at all. I felt like this report actually validated my initial concerns about this case, because it states that when Hayden needs help from his homework, he receives it from his mother or his teachers. Dad says, ask your teachers, ask somebody else at school. Hayden informed that he resides with, let me see, I've marked some. Hayden does say his preference is to spend an equal amount of time with each parent, 3 days on and 3 days off. I'm not sure what he wants to do with the additional day. But father's home, he says that his concern is his dad's respect towards him. He leaves the dishes until I return to his house. He leaves my door open, but he closes his door and the dog goes through and trashes my room. I mean, he does not, Hayden's own words don't indicate any fear of mom whatsoever, any fear of repercussions about anything. He feels close to his mom, safe with his mom, bonded with his mom. I was concerned. Let's see, what was it? I was very upset by when I read that Hayden stated, quote, "I'm just happy that I only have 2 more years left, and then they won't have to deal with each other," end quote. This is a child who's way too involved in this litigation. This child should never even hear the words court and judge and litigation and custody, and he should just be able to pay attention and be concerned about things that typical 16-year-olds are concerned about. I don't want to say, like playing video games, but it seems to be, what most 16-year-olds are doing. I wish that they'd be a little more involved in other things, but he certainly shouldn't be involved in this litigation at all. I really it was so sad to me that this child just wants to fast forward his life and miss his teenage years, so that he can basically escape his parents, the burden that these parents have put on his head and on his shoulders, rather than carrying it themselves, is disturbing. Also, I really didn't like in the middle of page 4, quote, according to Hayden, both parents have used him to relay messages to the other parent, sometimes regarding extra visitation time. Hayden informed that his father has made negative comments about his mother, stating, quote, your mother is the Antichrist, end quote. His mother has stated, quote, your dad is a liar and a pedophile, end quote. Hayden informed that the court case began as a rape allegation towards his father when he was 3 or 4. That's all, end quote. He's too involved in all of this stuff. Also, the message to the judge on page 5 states that Hayden wants to have the flexibility to call when he wants to. He communicated that he feels he needs someone to talk to, someone to discuss his anger with before it gets too bad. This is so sad. I don't know. It's so sad. He would... It just shouldn't be this way. It just shouldn't be this way. But I am concerned about that Dad does keep the phone away from him.
Just to clarify on the phone, Your Honor.
The dad denies him access to use the phone and such. When he wants to. And yes, I did review Dr. Mullen's report, and I highlighted sections all throughout there too that I felt were relevant. On page 2 of Dr. Mullen's report, in the middle of the child interview procedures section, Chris stated that, quote, I just want him to be a kid, end quote, referencing, quote, when with mom, have fun. Be free, who he is, wherever he is, end quote. While Amber commented, quote, hopeful that we can let go of what started all of this, learn forgiveness, and move forward, end quote. These are excellent words, but the party's actions contradict these statements. This is, yes, I did read Dr. Mullen's report. I thought that it was very similar, actually, to the FMC report, in that Hayden does feel closer to his mom, but he's not even asking to spend more time with his mom. He's asking for equal time, which I thought was really mature on his part. On the last page, on page 14 of Dr. Mullen's report, it says Hayden views Chris as a brute who tries to control him and speaks aggressively towards him, while he views Amber as the more nurturing parent. See, these kinds of statements, and as you noted, her report went into more depth and had more procedural safeguards against outside influence here, and also she instilled certain procedures to ensure the fairness of her access to Hayden and the parents, and yet the results I felt turned out very similarly. As far as the my ability to reconsider, there's no rule. I'd be happy to consider it if you're able to point me to it, but there's no rule anywhere that says that a second judge can't reconsider what a first judge does, but I absolutely agree with you, Mr. Carmen, about how am I logistically supposed to be able to do that when I wasn't the one that was there initially. And that's why I actually had I don't remember if I had a conversation with Judge Forsberg, or if my conversation was just with my JEA reaching out to her JEA to see if she would be willing to hear the motion for reconsideration, since she was the judge. And the response that we received was that no, this case has been assigned to Department Z, and therefore it is Department Z's obligation to sit and hear this case. So there you have it. I am tasked with having to take a look at it and consider it. And the one thing that I have not done in this case so far is to review her hearing video, and I'm not sure that that is what needs to happen, but I did just hear about this wonderful new tool that's been made available where I can have the transcript done for virtually free through this system that I heard about from another attorney. So that is one more thing that I'm willing to do and take a look at that. And even as we've been speaking here today, a day has cleared up on my calendar for next week on the 14th. It's a Wednesday, and I would like to take that day to read the transcript from Judge Forsberg's hearing when she made her initial ruling on...
Your Honor, on that note of transcripts, and I'm sorry to interrupt the court right now, my client states that she has the court written transcripts of all of the hearings, and she's happy to provide Your Honor with whatever hearing you might want.
If you're able to email that to me, that would be great, because the
are we talking about official transcripts or
What's
informal
that?
one?
I'm sorry?
Are we talking about official transcripts, like through the clerk and recorder's office, or
Yes.
are they part of the record already?
Are they?
They're on file. You should be.
I think all of them are on file.
Yeah, I think they're part of the record, Your Honor.
All right, well, I'm going to read them. And when can you come back on the 14th? I really want to put some finality to this case for y'all. I would prefer the afternoon of the 14th.
I have an all-day trial that day in Department M.
Department M. And it's going to go forward?
Sadly, as of my last conversation with Matthew Friedman, it's going forward. I'm hopeful that it wouldn't, but I'm pretty sure it is.
Okay. All right. And
Are you talking about next week, Your Honor?
Yes, next week. On the 15th, I have a full day trial. However, there's a very good chance that might settle. On the 16th, what do I have? Yeah, I haven't had a... gosh, this is frustrating. Looks like the 22nd is still available, too. Yeah, the 20... Well, I'm not sure.
I'm wide open on that, Dave, so that's the easiest one of the bunch.
How about 22nd in the morning, Ms. Robinson? Oh, Ms. Robinson, I think you're muted. I didn't hear anything you just said.
Sorry. I have 3 hearings that morning. What time is Your Honor thinking?
Oh, wait. I see. Let me double check. Huh. I'm not sure why. it says that I've got to ask my JEA a question about the 22nd. There's a note on there that I don't understand. Let me see what that means. Oh, I see. Okay, she says that I can go ahead and use that date. So, how about the afternoon of the 22nd? 2 o'clock?
That whole day is wide open for me.
Ms. Robinson, 2 o'clock on the 22nd?
Sorry, yes, I can do that date, Your Honor.
All right, let's do that. We'll come back on the 22nd. Mr.
Can I ask out of curiosity? Oh,
Mr. Carmen, if you have any authority as to why I can't rule on a motion for reconsideration that was initially heard by a different judge, if so long as I read the record and I'm up to speed on it, then let me know.
Okay, I'll do the research. And just to clarify my argument, I think that this court would have to find that a judge committed like a clear error, like it would be a heightened burden. I'll find you some case law, though.
Okay.
I do recall there being some out there. Can I ask you a question, of Your Honor?
Of course.
If you were to set aside Judge Forsberg's order and grant an evidentiary hearing, how far out are you setting those these days?
You don't want to know.
Oh, okay. So we'd have time to do depositions and everything if that happened. The reason I was asking is maybe we could start doing depositions and start figuring out discovery quicker if you had something quicker. But if your trial schedule is that far out, I guess it wouldn't matter.
It's horrible. I mean, geez, between COVID, me and my whole staff being new and getting cases from every other department and having to motions for reconsideration all across the board on every other judge's rulings. I'm really working on it. I'm really working on trying to make it more manageable and available for litigants. I don't like it, but yeah, we just scheduled one today for March of next year. It's crazy.
Okay.
It's crazy. But you know,
I get nervous.
Get
nervous and
as dates become available, though, you know, as dates open up, I try to use them.
I get nervous in some departments because suddenly they'll grant a set aside and they'll set an evidentiary hearing for 30 days out, and it's a nightmare trying to coordinate discovery and depots. And
yeah, I wish I had that luxury, but alas, I don't.
The prevails of being a new judge, right?
Yeah, one of them. Okay.
I've heard other departments are struggling with that too from predecessor judges.
So we'll come back then. I'll see you in 2 weeks. I will read everything that Judge Forsberg did.
All right.
Will Your Honor accept my oral motion today on the attorney's fees for that last round of hearings?
I've been in your shoes too, Ms. Robinson. I have been in your shoes. I'm going. I'll rule everything all together on the 22nd.
Thank you, Your Honor.
Thank you, everybody. Have a wonderful.
Thank you, and I'm sorry again, Your Honor, for being late to the beginning of the hearing.
Oh my
sincere
gosh,
apologies.
no apologies. My gosh, with the technology. Oh, that's the other thing, the technology. Oh my gosh, the time that gets wasted because of that. All right, we'll see you in 2 weeks. Have a wonderful weekend, everybody.
Thank you.
Thank you,
Thank you.
Your Honor. Bye.